as well as panelist of the Arbitration Institutes. At present, this year, 2020, he has been nominated as the Global President of Chartered Institute of Arbitrators. And very interestingly, Mr. Francis has a tenure expanded in all these arbitration institutions in Asia as well as globally in the Western side. And today, I think interestingly, we can hear about the fundamental of arbitration. There's a backbone, what we call this arbitration clauses, and how to deal with these clauses and how to draft the clauses. We are going to hear from him in another 55 minutes. Welcome, Mr. Francis. Now, Sharuk.
Hello all. Myself, I am Sharukumar. I am from the Managing Committee of KFCRI. First of all, a very good morning, good afternoon, and good evening to all the attendees who have joined the KFCRI webinar session from different parts of the world. A quick brief through the housekeeping rules. We'll be having the session for a 1 hour session. The last 10 to 15 minutes will be reserved for question and answers. If the attendees have any questions, you can post it in the Q&A box. Kindly refrain from using the chat box to ask your questions. If you are facing any issues relating to audio or video connectivity, you can inform it to us through the chat box. On behalf of the Managing Committee of KFCRI, I extend a warm welcome to Mr. Francis Xavier to the first session of the KFCRI webinar series on the topic Effective Arbitration Clauses. So without much delay, I would like to move on to the session. Basically, arbitration has the advantage of being private and quicker in resolving disputes than the courts. So when we move to the fundamental of arbitration, it is the arbitration clause which is entered between the parties to a contract. This session will focus on what is an arbitration clause, how effective can an arbitration clause be, what are the defective elements that an arbitration clause can have, and what is the future of arbitration clauses. Without much delay, I would like to move on to my first question, sir. What is the level of care that needs to be taken while drafting an arbitration clause? And why is that level of care needed to draft an arbitration clause?
Thank you, Sharuk. Basically, I do apologize if you get some buzzing at the back because it's raining very heavily here in Singapore now. Now, in order to answer your question, Sharuk, as you know, when you have a dispute, the dispute will be resolved by the courts. And the only time you can take it out of the courts and have it, as Sharuk has just mentioned, privately through, let's say, arbitration or some other form of ADR. And the only way that will be effective is if you have a clear, unambiguous clause that is practical, that can be worked out, either for an adjudication process, a mediation process, or a med-up process, or an arbitration process. So it's very important that there be a well-drafted clause, because if you don't have a well-drafted clause, number one, you're going to be spending many months or years even fighting about the validity of that clause and whether that clause should be adhered to, and if it should, what it means. And two, the bigger risk is that some court will come to the view that the clause is unenforceable. So after fighting for about 1.5 years or 2 years through the courts and the appeal courts, the conclusion might be that you have to go to the court and have your case fought, which is not what you wanted in the first place. So great care should be exercised. Sharuk.
Thank you so much, sir. So as you have explained, what is the care that needs to be taken while drafting an arbitration clause? We come across various clauses which are defective in nature. There are various elements in an arbitration clause which make it defective, or more precisely pathological arbitration clause. So from your experience, sir, can you share a few elements which are evident in making an arbitration clause defective or pathological?
Thank you, Sharuk. Since I knew you were going to ask me this question today, I have prepared a slides. So maybe you can flash those.
Yeah, definitely.
And I'm going to talk about 5 things that we've seen in practice where arbitration clauses have gone wrong. Now, these are not the only 5, but these are the 5 common errors where arbitration clauses have gotten into trouble, right? So the first is where the clause simply says, if you have a dispute, it will be resolved by arbitration. It does not say arbitration where. It doesn't say it will be resolved by arbitration in Madras or Chennai, right? So if it says that, then you know that the seat of the arbitration is in Chennai, the seat being India, right? But sometimes we come across clauses that do not tell you what the seat is. Now, this is a huge problem, because every time you have a problem with the operation of a clause, where the seat is specified, you can go to the courts of the seat to have the matter resolved. But when you don't even have a seat specified, what's going to happen is the claimant, as best as he can, is going to say that the seat is one country, and then the respondent, if he doesn't agree, he's likely not to agree if he doesn't want the arbitration to proceed. There's going to be a huge fight, taking a lot of energy and time and court resources as to which is the proper seat. And so it's very important. And Atlas Power, a case that I mentioned at the slide, is one such example. And as you know, if you proceed in the wrong seat, the award is likely to be unenforceable. The recent ST Group case, which I had the privilege of arguing before the Court of Appeal in Singapore. So this is the first problem, right? And it's very easy solution. Make sure you set up the seat. The second one, and maybe Sharuk, you can move the slide. The second common problem that we find is that people, in their attempt to be creative, make reference to the clause to arbitral institutions that do not exist, right? And so if you go to the next slide, Sharuk, if you look at the Lucky Gold Star case, I'm just giving a couple of examples. If you look at the Lucky Gold Star case, there was a reference to the International Commercial Arbitration Association in Hong Kong. So what the clause basically says was there should be an arbitration if there are disputes, and the rules of the International Commercial Arbitration Association shall be applied. There was no such body. So this was a 1993 case. Kaplan J, Neil Kaplan as he was then, ruled that since that body didn't exist, nevertheless, the arbitration clause could be enforced, but they couldn't apply the rules of a non-existent entity, so they applied the arbitral laws of the seat, which is Hong Kong, in that case, all right? But in the next case that I give you as an example, which is between a Korean and a German company, they made reference to a Foreign Trade Arbitration Commission of the Korea Council for the Promotion of International Trade. It sounds so good that you think that such a body will exist. Now, no such body existed, and that was fatal to the clause, because the argument that the claimant made was that, look, even though the Foreign Trade Arbitration Commission doesn't exist, you could still have an arbitration under the KCAB, the Korean Commercial Arbitration Board. But there, the court disagreed and held that it's not a valid arbitration clause. All right. So that's the second problem. Please don't create your own arbitral institutions. The third error, if I could, would be where you have opted for institutional arbitration, say SIAC, and SIAC would have a standard clause, a model clause. And instead of adopting the model clause, Sharuk, someone tries to be creative and they change the clause. So as an example, if you look at the next slide, I think I provided for the case of Insigma, which is a 2009 Singapore case. Now, what happened there? The parties took a model clause. Usually, an ICC model clause will say ICC administered arbitration applying ICC rules, or an SIAC model clause will say an SIAC administered arbitration using SIAC rules. The parties there decided they wanted to use ICC rules, but they wanted it to be administered by SIAC. Now, party autonomy, the Singapore court says, fine, we will enforce it because SIAC was willing to administer an arbitration governed by ICC rules. Now, but that case was heard in 2009. In 2012, ICC amended its rules to say in Article 1.2 that where ICC rules are being utilized, only the ICC is authorized to administer the arbitrations. Now, so today, if you have a creative clause like that, you can understand that the validity of the clause may be in serious dispute because you're applying the ICC rules, and the ICC rules say where the ICC rules are applied, only the ICC can administer it, right? So be careful when you tinker with model clauses. Of course, today, you know, an arbitral institution like SIAC would be very flexible. Today, if you had a clause which says you will apply LCIA rules governed by, but to be administered by SIAC, that will be valid, but not in the case of ICC rules, arguably so. All right, so that's mistake number 3. Mistake number 4, Sharuk, if you could go to the next slide, would be you have poorly drafted tiered clauses, right? So tiered clauses are a dime a dozen, right? You see them every day. They are very common. And it's a good idea to have a tiered clause, right? Go to mediation. If not, then you go to arbitration. Now, the first thing you need to bear in mind is that if you say something like, prior to commencing arbitration, parties shall resort to mediation, full stop, that clause is likely to be struck off as being unnecessary verbiage and completely unenforceable. Why? Because it's vague, it's unspecific. So if you want a valid precondition, you need to make sure you set out clearly, right? You need to say something like, if there's a dispute, parties need to resort to arbitration before they can commence arbitration. And mediation should be resorted to for a period of 30 days between, you know, the CEO of both companies or equivalent or someone that the CEO nominates, something like that, right? Where there's a clear mechanism, there is a clear time frame, it is clear how that process will work, right? So the first concern is that if there is a precondition, please make it clear and specific with timelines. Sharuk, next slide. Now, the second problem that we have with tiered clauses, and this is quite surprising, and that came up in the recent case that I mentioned in the ST Group, the casino dispute case. So there the parties said, I'm not sure if the thunder and lightning is getting in the way, but in that case, what happened was the clause said, when there's a dispute, you go for dispute resolution in the Laotian courts. So what happened? There was a dispute and the case went to the Laotian courts. Level number 1, there was an appeal. Level number 2, there was a further and final appeal. It went to the Court of Cassation, the highest courts in the Republic of Laos. Now, Sanam, the losing party in Laos, the American party, was unhappy with that decision because they lost. And the arbitration clause actually said the party who is unhappy with the decision can then commence an arbitration. So Sanam then commenced an SIAC arbitration. Now the question there that we raised was that such a clause is invalid because of public policy. How can you say, I have a problem, I will let the court rule, and when the court rules, I don't like it, I can go and ignore the court ruling and go to arbitration? Now that question wasn't decided finally in that case because the court felt that the full arguments were not before it in terms of Lao law, but the court decided that on another point, which is in any event the award was unenforceable because this wrong seed was utilized. The English court in Krupa also agreed with the point that I'm making, which is it's not logically possible to have a multi-tiered clause like that. All right. So error number 4, just bear in mind, if you have a tiered clause, have certainty and choose court or arbitration, you can't have one, you can't have both in succession. All right. The last mistake that I want to talk about, which is error number 5, is conflicting dispute resolution clauses. Now, this may sound to you like it came out of a comic book, but we've seen clauses in contracts where one clause in a contract says if there's a problem, you go to court in Australia, and further down the contract, another clause says if there's a dispute, you go to arbitration. Now, so when you have two conflicting clauses in the same contract, I don't need to tell you, you can imagine the kind of problems you're going to run into. So the courts invariably in such a case will have to make a choice, which one to choose. They can't choose both. Some cases, like the Transocean offshore case, the courts have held that being pro arbitration, they've held that obviously the weather agrees with the point that I'm making. So the courts in the case of Transocean felt the arbitration clause is the primary clause, and where there is an issue in the arbitration, you can go to court under that clause to get the court to assist you. Now, but depending on where the seat of your arbitration is and the role of the seat courts, and if you've specified a court in that other clause which is not the seat of the arbitration, you may run into pragmatic difficulties. So it's not a good idea to have conflicting jurisdiction clauses. So Sharuk, I think the last point I want to make, I think that's the last slide, is that sometimes you have more than one contract and the two contracts are related. So one may be a supplemental contract and one is the main contract, as in the Ui Hong Leong case, and then you have two different dispute resolution mechanisms under those two contracts. In such a case, the only solution for the court is to try and decide which contract the disputes comes under, right? But you know, there are all these difficulties when you obviously haven't paid attention. Going back to the first question that Sharuk asked me, how much of care needs to be taken? The answer being, please take extra care. It's just one clause. Unless you want to be spending a lot of money on behalf of your clients money is going to be spent on lawyers and time litigating. Sharuk, I'm in your hands.
Yeah, definitely, sir. Thank you so much. I guess it was an eye-opener on how an effective arbitration clause can be drafted and what are the basic defects in arbitration clauses. I would like to quickly brief on what sir has explained. So, sir, Mr. Francis Xavier, he has explained 5 basic problems which are faced in drafting an arbitration clause. Basically, the first point was seat of arbitration or venue of seat of arbitration, which is the most important thing in any arbitration clause, which is going to decide on the courts having the powers, the place where the arbitration is going to be held. And the second point was mentioning a non-existent arbitration institution and appointing such institution to resolve the disputes. And the third point was the most interesting point, wherein tinkering of model clauses was discussed. Every institution has a model arbitration clause of their own. Like for example, KFCRI has its own arbitration clause and arbitrator appointment clause. In such clauses, when tinkering or few additions are made to that clause, it is going to end up defective. And the last 2 points were badly drafted tiered clauses and clauses which in a same contract having the clause to go to court litigation as well as other forms of dispute resolution. So thank you, sir. It was definitely an eye-opener on defective arbitration clauses. So speaking about this, my next question to you would be on argument or clauses. So arbitration is one form of dispute resolution, one of the alternative dispute resolution mechanisms other than court litigation. We have various other ADR mechanisms, like speaking about mediation. So when we combine arbitration and mediation, the result is arb-met arb clause. So I would like to ask you, what is an arb-met arb clause, and how these arb-met arb clauses can be effective in resolving commercial disputes?
Thank you, Sharuk. Now, you need to bear in mind that up, met up clauses simply say you go to arbitration, and then once the arbitration is started, parties have an option of going into mediation. And then if the mediation fails, you go back to arbitration and the arbitrator will resolve the dispute. If in the mediation you get a settlement, you go back to the arbitrator and a consent arbitration award is issued. Now, the reason why parties had up, met up clauses was because ultimately, if there's a settlement in the mediation, they wanted to go back to the arbitrator and have a consent arbitration award, because an arbitration award can be enforced in more than 160 countries around the world, right? Previously, right? Whereas if you just settle it by way of a contract, if there's a problem with the mediation settlement agreement, you will have to sue all over again. You will not have an enforceable award. So that's why parties had up, met up clauses. But today, the situation has changed somewhat, right? Because you have the Singapore Mediation Convention. Of course, it doesn't have 160 over parties. It has something between 50 and 60 countries have signed up and putting in place the infrastructure. But as time goes on, the Mediation Convention will apply to a large number of countries. Now, what the Mediation Convention and the countries that have signed on to the thinking says is that a mediation agreement can be enforced almost, if not exactly like an arbitration award in the signatory countries where it's enforced. So in time to come, it doesn't matter. You can just have a freestanding mediation. You have a mediated settlement, and that settlement would be enforceable. But until the infrastructure of the Singapore Mediation Convention is in place in a larger number of countries, and firmly in place even in the signatory countries, you need to up, met up clauses will continue to be popular.
Definitely, sir. Thank you for sharing your thoughts. So speaking about arb, met arb clauses, the current trend, what everyone is discussing worldwide, is about the force majeure clauses. So after the COVID-19 pandemic outbreak, everyone is worried about their force majeure clauses and frustration of contracts. So my next question to you would be, what is the need for a force majeure clause, and how these force majeure clauses are going to be effective and going to operate in this COVID-19 situation, and post this COVID-19 pandemic, how are these force majeure clauses going to have an impact on existing arbitrations and future arbitrations to come?
Okay, so a force majeure clause, so you have a contract, right? Let's say, Sharuk, you have a contract with someone else to supply goods, right? And now COVID comes in, and you can't supply it because of COVID. Now, what you will do is you will look at your contract to see if there's a force majeure clause. Now, if there's a force majeure clause that covers the COVID situation, then the court will apply that clause. So whether you can get out of the contract, whether you have to pay any compensation, whether the contract is terminated, all of those issues will be decided according to the construction of that clause. Now, if the clause says, even if there's a viral pandemic, you still have to supply the goods, then the court will say, you have taken on a very strict obligation. Because, a force majeure clause is a clause where you foresee what will happen and you provide for it. Now, but if you have a force majeure clause, firstly, you may not have a force majeure clause. If you don't have a force majeure clause, or you have a force majeure clause that talks about accidents, earthquakes, tsunami, but not about viral pandemics, and the court says that the force majeure clause doesn't talk about viral pandemics, then you don't come within the clause in the contract. The only thing you can rely on, and I'm assuming the participants who are here with us today are from the common law countries, right? In the common law countries, you have the doctrine, as you mentioned, Sharuk, the doctrine of frustration. The doctrine of frustration is a very high doctrine which says the minute a contract is frustrated, then all bets are off. The contract dies. The contract is terminated by operation of law from the date of the frustrating event. Now, but the standard is very high. The test, while the courts use radically different obligations, the underlying test is always supervening impossibility, Shahrukh. So you must be able to establish that it is impossible for you to perform the contract. Now, even though there is COVID, if you had promised to supply 50 tons of brinjal to somebody else, the brinjal supply lines are still running, right? Even with COVID in place, the food supply chains are still running. They have not been shut. So there is no frustration, right? But if you were supplying Tupperwares, right? You can't, because in a lockdown, that's not essential. Unless you're in partial lockdown and you still can do it. So it's very fact sensitive. If you can show it is impossible to carry out the contract, then there will be frustration, right? Now, the interesting thing is when you entered into the contract. If you enter into a contract today with the pandemic raging and you didn't provide for a force majeure clause, then it is very hard for you to say that this pandemic is not foreseeable. Parties, never thought of it, And so if you enter into a contract today, despite the knowledge of the viral pandemic and make certain obligations, the chances of you saying it's frustrated because of the pandemic, I think it's simply not there, right? So that would be the impact of timing, whether you entered into the contract before the pandemic. But, even if you entered into the contract in an early stage of the pandemic, say you heard about Wuhan having problems in December or January, you could say, we didn't foresee that it will spread all across the world and shut down the world, So it's very fact sensitive, Shahrukh.
Thank you, sir. I guess our doubts regarding this COVID-19 was clarified. If you have any questions regarding this, you can please mention it in the Q&A box. So speaking about COVID-19 and force majeure clauses, my next question would be, what will be the fate of arbitration hearings in the COVID-19 pandemic? Now, everywhere we can see online dispute resolution mechanisms on the go, and where we have so many virtual hearings happening and arbitrations through the internet. What is the future of ODR and how online dispute resolution is going to facilitate this COVID-19 situation? And speaking about arbitration clauses, can we incorporate a clause regarding online dispute resolution while entering into the contract or entering into the arbitration agreement itself?
Okay, Shahrukh, I think first let me take the first question that you asked. What's the impact on arbitration hearings? Today across Asia, I'm sure also in India, the courts are shuttered, right? The courts are not operating because of COVID, right? What is happening to arbitration hearings? Now, to my knowledge, a number of arbitration hearings are proceeding by way of virtual or remote facility, right? Teams, BlueJeans, Zoom, all these online platforms. So last week in an arbitration where I'm the sole arbitrator, there was a hearing, full-blown hearing involving parties from the US, London, China, involving expert conferencing, experts from different parts of the world. There were 3 experts involved. It was a valuation issue of a diagnostic genomic company. And we proceeded by way of a virtual hearing. So my sense is that many arbitrators have already been carrying out, because of the landscape, right? International arbitration is multifactorial. You have counsel from different countries, arbitrators from different countries, experts and witnesses from different countries. And many of these hearings have been conducted in the past by way of virtual or remote hearings. And if you know, just on that point, I want to flag that the Chartered Institute of Arbitrators has recently just released sort of guidelines on remote arbitration hearings, right? So that's a useful tool. So with the COVID moving forward, we are likely to see that more and more people will realize that, because the default position before was we want a face-to-face hearing, but now they're forced to go into virtual, and many of us are discovering that the virtual platform is as good as it gets, right? In most cases, it is sufficient. You don't need to get people to fly 10 hours or more across the globe and be in the same room to get the, and so you get a lot of saving in cost, time, flexibility. And so the use of virtual remote facilities beyond COVID is just going to ramp up. That's the sense we get. Now, the last part of your question relates to online dispute resolution, ODR. Now, online dispute resolution, I think people again will realize it's not resorted to so much today, because people are just creatures of habit. ODR is not part of their habit. But I think COVID is going to change that. People are going to realize that online dispute resolution is efficacious, is pragmatic, is cost efficient, and it will work, right? And so ODR, I think, is going to take off. The only last thing I want to say, where there is a need for arbitral institutions like KFCRI and other institutions across the world to look at, would be a crypto arbitration platform. You know, so you have distributed ledger technology, smart contracts, which are self-executing without the interposition of human beings. And there is a rallying cry across the world for crypto arbitration platforms or crypto ADR platforms, where you can actually, parties can key in their dispute, and the dispute would be sort of resolved without the interposition of certainly physical human interaction. So that's something that, and you know, smart contract platforms, distributed ledger technology platforms are widespread, from real estate transactions, insurance transactions, share transactions all across the world. So this is a crying need, and whichever institution can play a leadership role on this, you know, will be recognized to be a market leader. So thank you for that good question, Sharuk.
Thank you, sir. So I guess your view is that ODR is going to be the future, and online dispute resolution is going to change arbitration in a positive way. And
That's right.
Since you were explaining about the minimization of cost when it comes to ODR, I would like to put up a question relating to cost in arbitration clauses. So, is it possible to apportion the cost of arbitration at the time of entering into the arbitration agreement itself? Can the parties decide on how the cost of arbitration is going to be apportioned among them, while at the time of entering into the arbitration clause or the contract, principal contract in itself?
Right. So, you know, there are certain aspects of arbitration which are its key pillars, right? Competence, separability of the arbitration agreement, and the third pillar would be party autonomy. So party autonomy, competence, separability will be strictly adhered to unless public policy dictates otherwise. So in a case like this, where you have an arbitration clause and you say right at the start, if there's a dispute, there'll be an arbitration under the KFCRI rules, and the cost of the arbitration will be divided equally, regardless of the outcome. Right? Sharuk, that's your question.
Yes, sir.
So in that case, party autonomy. Parties have agreed. There is no reason why public policy will intervene to prevent the parties from achieving it. So it will be enforced. Now, in the case that I told you, where you say in your clause that you go to court first and then you go to arbitration, that is likely not to be enforced because from a public policy perspective, you can't allow that level of party autonomy, right? But otherwise, party autonomy rules, Shahrukh.
So, thank you, sir. So, I guess we'll have some of the questions from our attendees. Our Q&A box is already flooded, so we'll start with some of the questions from our attendees. The first question is from Ananya Pratap Singh. So, the question is, dear sir, Indian courts have time and again had upheld the pathological incompetence arbitration clauses, interpreting the intentions of the parties to arbitrate their dispute. For example, in cases like Enercon Limited and others versus Enercon and another, Glencore International AG versus Indian Potash Limited, to name a few. Do you think it is against the doctrine of party autonomy and unfair for the other party?
Well, I know Mr. Ananya Pratap, and so I'm happy to answer this question. Now, obviously, the courts in India, from what is being said, are trying their best to apply effective arbitration, effective construction of arbitration clauses to give them life, which is the trend across the world. So in Singapore, for instance, we've had a number of cases where, like in India, we've had situations where the clauses, if you look at the clause, you get indigestion immediately, right? But the courts have interpreted the clauses in a way where the court says, look, I'm going to allow it to go to arbitration in this manner, because this is what I think the parties intended, and we will honor that. So in a way, by giving life to what appears to be a pathological clause that gives you indigestion, the court is honoring the parties' choice of arbitration, because the parties, after all, have a clause that says they want to go to arbitration, right?
Thank you, sir. So the next question is from Mr. Ajay Francis Loyola. During an ongoing arbitration, can the parties amend the arbitration clause?
Right. So again, this is party autonomy. Remember what I said earlier. Party autonomy rules unless you hit a public policy wall, right? So the general principle is that the parties can agree at any time, right? So there is a dispute that starts in the contract. There is no arbitration clause. The parties can decide, right? Right now, the dispute arose yesterday. We'll go for arbitration. So they can agree at any time. Now, let's say the parties agree on the 1st of January to go to arbitration, 3-man arbitration to be administered by KFCRI under the KFCRI rules. And the arbitration starts, right? And on the 1st of February, and then there is a 3-man panel appointed, but the arbitration hasn't started, right? And on the 1st of February, as the 3-man panel is about to write to everyone, the parties both agree, you know what, after we've seen the charge out rates of the arbitrators, we want to have only one arbitrator, right? So we've come to an agreement. It will only be one arbitrator. I think it is still possible to respect the party's choice, right? But if, let's say, the 3-man arbitrator spends 6 months hearing the case and on the 1st of August, they're about to deliver their verdict. And then, on the 28th of July, the parties decide to agree that they will switch to a one-man arbitrator panel. That may be something that the court will say, look, it's just too late. From a public policy point of view, it doesn't make sense for us to allow you to tinker with the architecture of the arbitration so late in the day, right? So I think it is fact specific. Generally, the courts will want to honor the parties' intentions and agreement, subject to limits, public policy limits. Ajay, I hope I've answered your question.
Thank you so much, sir. So next we have an interesting question from Mr. Karthik Sridhar. This question is, sir, in an ARB-MED-ARB clause, can the arbitrator and the mediator be the same person?
Now, this is the perennial challenge that we common lawyers face. All right. If you look all across, and the majority of the globe, civil law countries, is very accepted, fairly usual and common for an arbitrator to switch to become a mediator and then switch back to an arbitrator. In the common law countries, we not only get indigestion, we get diarrhea when we hear about something like this, right? Because we think, how can an arbitrator become a mediator and have private caucuses with the parties, and then he may hear something that the other party doesn't know he has heard, some defamatory statement, some secrets that he's not supposed to hear, and then he switches back and becomes an arbitrator. Now, let me tell you that as a common law trained lawyer, I too have problems with that concept, but you need to realize that across the civil law countries, that switch works very well, has not given rise to significant problems, right? So my sense today, after having seen enough, is that if you've appointed an arbitrator who knows what he's doing, the arbitrator will be able to separate the boxes and wear the right hats. But of course, every rule has an exception. There may be cases where you simply can't, because the case involves allegations of fraud, very serious allegations that impugn credibility, and once an arbitrator hears things, he can't unhear them. So it may well be that in such cases, you may have to appoint a fresh arbitrator. But in practice, my sense is that in many, many cases, that's not necessary.
Thank you, sir. So the next question is from Mr. Jatinder Vadwa. His question is, in India, we have jurisdictional clause wherein we say that particular courts will have exclusive jurisdiction as well as arbitration clause. So we have the power to move the court if we are not satisfied with the arbitration award. What is the use of having arbitration clause in the contract? Should we have only one clause either going to the courts or going to the arbitration? Please guide.
Yes, that's a point I've made. Now, if you have a contract, page 1 says if you have a problem, you go to the court. Page 3 says you have a problem, you go to arbitration, you have a big problem, right? Now, courts will try and support arbitration, so they will try their best to give supremacy to the arbitration clause, right? But so if they give supremacy to the arbitration clause, then it will go to arbitration. If the court somehow come to the view that the arbitration clause is invalid and we need to enforce the court dispute resolution clause, then you go to court dispute resolution. You should not get a case where you go to arbitration and there's an arbitral award and the party who loses in the arbitration can then go to court. That's exactly the kind of problem that I spoke about, where you have both court resolution and arbitration one after another sequentially. It does not make sense, right? So that must surely be against public policy.
Thank you, sir. So we have another interesting question from Mr. Ananya Pratap Singh. Can financial inability to perform the contractual obligations may amount to impossibility to perform a contract and in turn provide a right to terminate the contract?
Now, both under the construction of force majeure clauses and the doctrine of frustration, the courts have been very clear. In force majeure clauses, of course, it's what the contract says. If the contract says in subclause E of the force majeure clause that if the prices go beyond 150% prices of raw materials, and then you will be excused, so be it. Because force majeure is basically interpreting what the parties agreed. If the parties have, in their clause have agreed that if raw material costs go up beyond a certain factor, you're excused, that's fine. So it all depends on the clause. But if the clause does not allow you, the clause simply says, you know, where there is impossibility of performance, for instance, which is what most force majeure clauses will say, an increase in price of raw materials, you know, the fact that raw materials have gone up by 3 or 4 times is not going to excuse you. The courts in Glahi, this case called Glahi in Singapore, have said that perhaps if the price has become astronomical, you know, maybe 300 times, perhaps then the court might say force majeure. Same thing for frustration. Unless it's astronomical, no case has succeeded on an astronomical basis as far as I'm aware on the planet, right? So the general answer is substantial increase in price, great difficulty in performing the contract will not help you if it still can be shown that you can perform it. Only if it's impossible to perform it will you succeed, for instance, in frustration. Force majeure, it depends on what the clause says. Thank you.
Thank you, sir. The next question is from Ms. Kritika Bandari. Her question is, what is your view or take on unilateral arbitration clauses? Say about unilateral appointment of arbitrators. It has been decided by many courts, including India, that unilateral clauses are void and invalid. So considering this, doesn't it affect the party autonomy?
All right. Yeah. So unilateral clauses, by that I understand that to mean to say you have an arbitration clause and it says if there's a dispute, so there's a contract between A and B, and the clause says if there's a dispute between A and B, only A is entitled to commence arbitration. B cannot commence arbitration, right? So that's a unilateral clause. Now, different countries in the world have treated it differently. Remember the principle we spoke about. Courts will honor party autonomy unless you hit a public policy brick wall. So in Russia, for instance, such a unilateral clause in the Ericsson case was struck down as invalid because the Russian courts feel that as a matter of public policy, they will not allow a unilateral recourse to arbitration by one party. The clause must allow either party to enter into an arbitration or to commence arbitration. Now, in Singapore, if I'm not mistaken, there was a case where this was considered and the court said either in ratio or obiter that, and I don't have the citation off the top of my head, that we will enforce it because it's party autonomy. This is exactly what parties agreed to. There was A and B agreed that only A will have the right to go to arbitration. What's wrong with that, right? Now, but different courts in the world, I agree, will ascribe different limits to public policy, right? So you need to be clear that the seat of the arbitration will, and the country where you will enforce the award will honor such an agreement, a unilateral. So certainly if you are going to have your arbitration seated in Russia, or from what I'm hearing in India, then you shouldn't have unilateral clauses.
Thank you, sir. I guess we have many questions from the attendees regarding confidentiality in online dispute resolution. So I see many questions wherein the parties have agreed for arbitration but unable to proceed and decide on going for ODR. How the arbitral tribunal or the arbitration institution is going to confirm with the confidentiality of the proceedings and confidentiality of arbitration?
Now, I think the first thing you need to bear in mind that it's true that, you know, everyone says that people go to arbitration because of confidentiality, but you need to understand that on a day-to-day level, not all arbitrations are confidential, right? So you take ICC rules, arbitrations, they're not confidential. If you look at the ICC rules carefully, the parties have to make it confidential, or there is a mechanism by which under the rules they can apply and there be a confidential order, but it's not automatically confidential, right? SIAC arbitration is automatically confidential, and it also depends on the lex arbitrii. You know, some countries say that arbitrations are confidential. In some countries in the continent, in Europe, arbitrations are not confidential. There are specific provisions in the civil codes of certain European countries that say that arbitrations are not confidential. So arbitrations are not automatically confidential. They will become confidential if your arbitration clause says it's confidential, or the rules that you are applying, the arbitral institution rules that you're applying says that it is automatically confidential, or the lex arbitrii, the law of the seat, the national law of the seat says that such arbitrations are confidential. So unless you satisfy one of these three criterion, or all or more, then it will be confidential, right? But in many cases they don't. So don't assume that it's confidential. That's one. Number two, assuming yours is an arbitration that is confidential. I agree. If you have an ODR, and we've just heard news that Zoom, the platform Zoom, has been hacked, was hacked in Singapore, right, recently. So the Ministry of Education has barred the use of Zoom. Many offices, like my firm, have included password use, even for Zoom platforms. So I can't just press on a link and get in. I still need to key in a password, right? It is encrypted. So I guess the challenge is a technological one. As we go on to ODR, the hackers are going to find ways to hack into your hearing. And the counter hackers, the counter insurgents, are going to find ways to prevent them. It's going to be a continual technological battle, but you know, you need to have those layers of protection. So if you're counsel, you're right. One of the key aspects of going ODR or into virtual remote is to pay a lot of attention so that your process, the process of your hearing, is not infringed or interrupted or hacked into by unwanted parties.
Thank you, sir. So I think we are almost nearing the end of the session. We'll quickly brief with one final question. We have one general question which will be helpful if you could help it on us, and which is a career development question. So how does one get into the practice of arbitration or become arbitrator and get clients?
Okay. I think I would say play a full out game, right? Do whatever you can in your power to learn and become an expert in arbitration, right? So read more, take courses, get accredited with the CIR, you know, persuade the firms that you're with. You know, Inba, for instance, of the KFCRI, is a trainer. You know, I've trained with him in Myanmar. So get accredited, you know, be a fellow, become a trainer, take part in the CIR activities in India, meet other like-minded individuals, brainstorm, you know, topical issues, become a repository of information, right? And all of us know how to do it, right? Reach out to people, be actively engaged in the community, you know, start being helpful to the community. If a leading case in India has come out, you don't need to write a 15-page article, because nobody reads a 15-page article, you know. And if you have a 15-page article, God forbid, make sure you have a very useful 2-paragraph or 3-paragraph synopsis, because everybody is just going to read the synopsis and move on with their daily life, right? So just come up with a half-a-page or 1-page case analysis. Why is this case important? What is the impact of this case? You can summarize it in 2 or 3 or 4 paragraphs. Do that, you know, and people will start remembering you. You're the guy who helped them to remember the significant case development without spending 2 hours reading the case, right? Speak at conferences slowly as you become more senior. You know, get to know people. Keep doing that. most importantly, believe in yourself, right? Many of us don't do the things that calls out to us, right? You can see immediately, you may not know what's going to happen in 5 years, but if I were to ask you now what you can do, you will have an idea what you can do right now. Maybe get trained, maybe keep yourself abreast with the latest developments, maybe write a case note. Just do that and keep doing that, regularly. Constantly ask yourself this question at the end of a day: what did I do today that really worked? Maybe you interrupted your busy schedule and said hello and had a good 2-minute conversation with the tea lady. That worked. Replicate it throughout your life. Second question: what could I have done today that would have meant I could have finished a specific task better, faster? Every day of your life, right? How could I? And so you can modify it. What could I have done today to have progressed my arbitration career? Get that answer. The answer will come to you. Do it and keep doing it, and you will get there for sure.
Thank you, sir. So I guess we are in the end of the session. We have many questions flooded in our Q&A box. You can reach us through kfcri.adr@gmail.com. We'll try our best to reach it to Mr. Francis Xavier and get your answers. And on behalf of the managing committee and KFCRI, sir, we extend our heartfelt thanks and gratitude to you. Any concluding remarks from your side, sir?
No, I think I get the sense that many people out there, want to make a mark for themselves, right? So it can be done, right? It starts with you having a long-term goal, visualizing it, and build that confidence. Know that you can do it, right? You're a child of God, and have that conviction. You will get there, and you will get there, because when you have the conviction that you will get there, nothing can stop you. And every day, or every week, ask yourself, I'm going to get there. What do I have to do this week to get there? And you will know what you have to do. Don't shirk. And if you do it, you will get there, and many before you have gotten there, and you will get there for sure. All the best. God bless you. And, stay safe in this very difficult and challenging times when our entire planet is on its knees because of a tiny virus.
Thank you, sir. I would request Mr. Inbavijayan to give a few words about conclusion.
Thank you. Thank you, Mr. Francis Xavier. It is two interesting things we can get from the presentation made by Mr. Francis Xavier. One thing, focus, and another thing, energy. The energy, what you can see from Mr. Francis, I could remember the days when we are doing Myanmar training. The energy was abundant, 2.5 hours, continuous teaching to bring effective arbitrators. That is the most interesting thing. We have many arbitrators, but we need to have effective arbitrator to bring this particular arbitration clause to be executed in a perfect manner. Thank you, Mr. Francis, and the great words of the Global President of Chartered Institute of Arbitrators. And most interestingly, Francis was the first person to be facilitating KFCRI as an advisory board member. We are grateful to him, and we take this opportunity to thank Francis for consenting to be part of KFCRI in this promotion of a wonderful area of law of practice, which is arbitration to add on mediation. And I was very happy to hear from Francis about mediation also, even though practitioners like Francis and me, we have a passion too much into arbitration, but mediation now offered this UNISA, United Nations International Settlement of Agreements. It is also going to be a parallelly good avenue for practitioners and young practitioners. Take this seriously, and whatever advice he has given, from drafting an arbitration clause till how to reach a good career, take this and be in touch with Mr. Francis. Anyway, our team would share the coordinates of Mr. Francis so that he can be in touch with Francis subject to his availability. And now he is available because of the lockdown. Otherwise, very hard to reach Francis. And thank you. Wholehearted thanks to Francis. and the team members were coordinated. And now I'll give it to Svetan to say the final words.
Thank you, sir. Thank you, Mr. Francis. Thank you, Sharukumar, Mr.Inbavijayan. And I must give my wholehearted thanks to the KFCRI team who's been working behind the curtains as well. Finally, a bit of logistics. We have our next webinar on the 23rd, which will be the lead panelist will be Mr. Aaron Downey-Hussey. Please join through the registration link, which will be shared to you via email as well. Thank you. And if people who are unable to see this webinar or you would like to share this webinar, we will reach you via mail with the recorded version as well. Thank you so much.